Assalamualaikum warahmatullahi wabarakatuh everyone. My name is Nurul Nabilah binti Muhammad Syajahan and my groupmates are Nurul Azrin Ashikin binti Zahari and Nur Naziha binti Yunus. Today we are going to present our scenario. So let's watch a video that shows the synopsis of our scenario. Gombak Wildlife Zoo has been a very popular tourist attraction. The owner, Selangor, had decided to keep the entrance fee low to draw visitors and to promote sustainable biodiversity. It was intended to serve as an educational public facility rather than commercial tourist attraction. 3 wild pandas that recently arrived from China have sparked more interest to see the animals. The zoo, for the first time, offers Feed the Panda experience, allowing visitors with special ticket to feed pandas with bamboo leaves and stems.
The panda will be securely tied with a small chain in one leg, and visitors will be accompanied by a trained zookeeper at all times. Several notices were pasted alerting visitors to be cautious of wild pandas and follow zookeeper's instructions. One day, Apao, his wife Debbie, and their 6-year-old son Achin visited the zoo and bought tickets for the Feed the Panda experience. Raju was assigned to accompany them to enclosure. Raju noticed a poorly tied chain in the panda's leg, but ignored it, assuming the panda was small and not typically aggressive towards humans.
Appa was feeding a panda with bamboo leaf when his son kicked the panda's leg, which angered the mammal. Consequently, the panda attacked Appa, biting his left thigh before Raju restrained the panda. Appa was immediately taken to the hospital for treatment due to his injuries. Appa plans to file a negligent action against the zoo management and Selangor, who maintain their innocence due to the necessary safety measures.
So from the video, it can be extracted that the parties involved in this scenario are Mr. Apao as the plaintiff, Gombak Wildlife Zoo as defendant 1 and Selangor State Government as defendant 2. And the legal issues are, firstly, whether Gombak Wildlife Zoo is liable for negligence for the injury suffered by Apao. Second, whether Selangor State Government is liable for the negligence towards Apao for the injury he suffered. And lastly, whether there is a contributory negligence on behalf of Apao and his family. So our first main issue is whether Gombak Wildlife Zoo is liable for negligence for the injury suffered by Apao. To answer that issue, we have developed more sub-issues. The first sub-issue is whether Gombak Wildlife Zoo owes duty of care towards Mr. Apao as their visitor. Duty of care. The rule that we are using to identify the existence of duty of care is the Kaparo test. In the Kaparo test, 3 elements must be fulfilled, which are forcibility of damage, sufficient proximity between plaintiff and defendant, and lastly, fair, just, and reasonableness. If all 3 elements are fulfilled, that means there exists duty of care. The Kaparo test derived from the case of Kaparo Industries and Dickman. In this case, Mr. Dickman, who is an accountant, had made a report showing that the company had made a profit over £1.3 million. But later, it was discovered that the company had actually made a loss over £400,000. The Kaparo Industries, not knowing that the company is actually bankrupt, had invested their shares in it. And later, when they found out, they sued Mr. Dickman for his negligence on preparation of the account. However, the court held that Mr. Dickman owes no duty of care towards the Kaparo Industries because he knew nothing about the existence of Kaparo and he did not aware that the account that he made will be relied on by the future investors. So, that means there is lack of proximity. There is no sufficient proximity, which means one element of duty of care is missing, and that means no duty of care. Now we will explain further about each element of duty of care. The first element is forcibility of damage. We use the case of Kupon and Pemandangan Sinar Sdn Bhd. In this case, plaintiff's family member were kidnapped and the defendant, who is a newspaper publisher, had published an inaccurate article regarding the kidnapped victims. This led the kidnapper to demand additional ransom. And then the negotiations failed since the plaintiff could not fulfill the additional ransom. And the plaintiff sued the defendant for his negligence in writing an untrue report. In this case, the court held that there is lack of forcibility of damage, which is one of the important elements for duty of care to exist. No reasonable man could have foreseen that such consequence would happen when the newspaper publisher published an inaccurate article. And the injury suffered by the plaintiff was merely a possibility, not a high probability or highly likely one, and plaintiff had also failed to establish the relationship of proximity and failed to prove that it is just, fair and reasonable to impose liability on the defendant. The next element is proximity of relationship between plaintiff and defendant. We use the case of Yuan Kunyu and Attorney General of Hong Kong. In this case, the appellant had deposited money with American and Panama Finance Limited, which is a registered deposit-taking firm located in Hong Kong. Then, the appellant lost their deposits when the firm entered into liquidation. The appellant then claimed the Attorney General of Hong Kong, who represented the Commissioner of Deposit-Taking Companies, owes duty of care to them to license the company only after careful scrutiny as to its safe financial position. However, the Privy Council dismissed the appeal because, number one, there was no special relationship between the Commissioner and these depositors. They were not neighbours and there was no duty of care owed generally to all of the potential depositors. Second, the Commissioner had no power under the Deposit-Taking Ordinance to control the management of deposit-taking companies. And lastly, the relationship between plaintiff and defendant was not sufficiently close and direct. And the last element is just fair and reasonableness. Use the case of Mark Rich & Co. and Bishop Rock Marine. In this case, a ship was carrying claimant's cargo when it developed cracks in its hull. And then they called a marine classification society to consult to determine the extent of repair that would be required to their ship. The surveyor of the society approved for temporary repair, as it would have been expensive for a permanent repair. Then, relying on the consultation, the ship resumed its voyage and few days later, it sank, causing the plaintiff's cargo to lose. The House of Lords held that no duty of care was owed by the Marine Classification Society to the plaintiff. Though two elements are fulfilled, which are possibility of damage and sufficient proximity, but it is not fair, just and reasonable to impose duty of care towards the classification society. Why? Because number one, the society is a non-profit making organisation. Second, law of international trade already covers such incidents by insurance. And third, the recognition of duty of care owed by classification society to cargo owners will potentially expose to large claims by cargo owners. Applying the element of foreseeability of damage, it is foreseeable that such accidents may happen to Mr. Apau or to any other visitors due to the panda's loose chain. A reasonable man in Raju's position as a zookeeper could have foreseen that the plaintiff would suffer injury if wild pandas is not securely tied, though it's a baby-sized panda. The likelihood that the plaintiff might sustain an injury was not merely a possibility, as it is foreseeable that pandas, which are wildlife creatures that had just arrived to a new place and are trying to adapt to unfamiliar environment, would act violently, especially if there is lack of measures took to control them. Next, applying the element of proximity. Proximity of a relationship existed as Mr. Apau is one of the zoo's visitor or customer. The proximity is sufficiently close, direct and not too remote. The zoo owes duty of care to protect their customers from foreseeable injury to their visitors in their premises. Raju, as a staff of the zoo, had the power to stop the incident from occurring if he stopped Mr. Apau and his family from entering the place, knowing that the panda is not securely chained. Lastly, applying the element of just, fair and reasonableness. It is just to impose duty of care towards the zoo, as recognition of duty of care to the zoo will make them more responsible in their management in the future time. The zoo should be responsible for the harm that comes from their own premise and must take reasonable measures to protect the visitors. The zoo gains profit from the Feed the Panda experience, and it was expected by the visitors to have enjoyable and memorable experience rather than traumatic ones. The lack of measures taken was the cause of this accident that happened to Mr. Apau. To conclude, all three elements of duty of care in the Caparo test is fulfilled, which is foreseeability of damage, sufficient proximity, and just, fair and reasonableness. So, duty of care by the Gombak Wildlife Zoo to Mr. Apau is established. Our next sub-issue is whether Gombak Wildlife Zoo breached their duty of care towards Mr. Apau. So, when is duty of care being breached? A duty of care is breached when standard of conduct is not successfully reached. To identify the standard of duty of care, we use the objective test of reasonable person. The defendant's conduct is tested against the standard of care which would be expected from a reasonable person. The question asked is what would the reasonable man have done or not have done in the same circumstances of the case. Breach of duty of care can be seen in the case of Takung Tabari and Government of Sarawak and others. In this case, one of the issues disputed is whether there is duty of care of bank to ensure safety of customers in its premises and whether such duty is breached. In this case, the plaintiffs were making bank transactions when an explosion of fire occurred. None of the employees of the public bank did anything after becoming aware of unfamiliar smell, although the smell should have prompted them to investigate. This omission led to explosion of fire, causing injury and death. The court held that the public bank owed duty of care and should have taken all reasonable precautions to ensure the safety of its customers in the premise. Since public bank through its staff did not take any reasonable or reasonably sufficient measures to meet its duty to prevent injury to its customer, the plaintiffs had established liability of negligence to the public bank as the occupier of the premise. The breach of duty of care through the omission is proven. In this scenario, Raja's omission or failure to take measures to prevent the incident resembles a breach of duty of care. Using a reasonable person test, a reasonable person in Raja's position would have taken an action upon seeing a loosely chained panda, as it may bring harm to the people, provoked or unprovoked, considering that the pandas are wildlife creatures and are new to the environment. Gombak Wildlife Zoo, through Raju had acted below the standard of reasonable person, which means they had breached their duty of care. To conclude, Gombak Wildlife Zoo, through Raju had acted below the standard of reasonable man, which means duty of care towards Mr. Apau is breached. Our third sub-issue is whether the negligence of the zoo management causes damage to Mr. Apau. Causation has two types, which are causation in fact and causation in law. Plaintiff needs to establish causal link between the breach of duty of care and the damage itself, and it must be present, unbroken, and not too remote from the damage. For causation in fact, we use the but-for test. The questions asked are whether or not the defendant's conduct has in fact caused the damage suffered by the plaintiff, and whether or not the damage would not have happened but for the defendant's breach of duty. To understand better, let's see the case of Hassan bin Datola and Kerajaan Malaysia. In this case, the appellant claimed that the defendant doctor negligently damaged his spinal nerve during an operation, leaving him paralyzed. He claimed that the doctor's negligence in performing the procedure was the sole reason for his paralysis. The issue disputed is whether the doctor's action during the operation procedure causes injury to the appellant's spinal cord. The evidence showed that the harm sustained resulted from delayed treatment rather than the doctor's negligence during the procedures, which means there is no causation of damage. The claim made by the appellant was unsuccessful since there was no proven causal link between the damages and the breach. The defendant's conduct does not cause the damage suffered by the plaintiff. Meanwhile, for causation in law, we use the reasonable foresight test that is established in the case of Wagon Mount. In this case, the defendant's ship, the Wagon Mount, was refueling another ship and negligently had spilled oil into the water, and no effort was made to clear up the oil, and the wind and tide causes it to quickly spread to the claimant's wharf. Welding operation was taking place on the wharf, which then caused the oil to ignite. The flames developed into a large fire which severely damaged the wharf. It was held that it is reasonably foreseeable that oil would seep into various parts of a jetty and causes damage to its usage, but it is not reasonably foreseeable that the fuel oil on the surface of the water would catch fire. So, the extent of liability would depend on the reasonable foreseeability of the damage. To apply the rules of causation of damage, causation in fact is proven by the but-for test. The question asked is whether Raja's conduct has in fact caused the damage suffered by the plaintiff. The answer is yes. Why? Because the injury suffered by Mr. Apau would not have happened but for the Raja's breach of duty. Meanwhile, causation in law is proven by the reasonable foresight test. The injury suffered is not too remote from the breach of duty. It can be foreseeable that wildlife pandas might act uncontrollably if not being chained securely. A reasonable man in Raja's situation as a zookeeper would foresee the potentiality for the damage to occur and would take safety measures to prevent the accident from happening. To conclude, this scenario fulfills both types of causation, which are in fact and in law. It is established that there is a causal link between the breach of duty of care of Raju in behalf of the zoo and the damage suffered by Mr. Apau. The causal link is not too remote, and Mr. Apau would not suffer the injury if not caused by the negligence of zoo management. So, it fulfills both types of causation, in fact and in law. Lastly, our sub-issue is whether liability of negligence could be imposed to Gombak Wildlife Zoo. The rule that we are using is vicarious liability. The elements of vicarious liability are: number 1, wrongful act. The wrongful act must have been committed by an employee or other agent. Second, the employee or other agent must have been acting within the scope of his or her employment or agency. And lastly, the employer or other person must have had the ability to control the employee or agent. Vicarious liability can be seen in the case of GMP Kaiser Securities Sdn Bhd and Muhammad Amirul Amin bin Muhammad Amin. In this case, a working contract was entered between GMP and Jaafar as the first defendant, wherein GMP took Jaafar under its employment as personal bodyguard. One day, Jaafar suddenly shot and killed Dato' M, the one he should protect, with a firearm provided by GMP on the highway. Then Jaafar got off from the car and fired randomly at members of public on the road. Amirul was riding his motorcycle and slowed down, assuming there was an accident, and asked Jaafar about it. Unfortunately, Jaafar then shot Amirul. Amirul brought an action against Jaafar to hold primary liability and against GMP on the basis of vicarious liability for Jaafar's action. The court held that it was GMP who was responsible for employing Jaafar and enabling him to carry the firearm. Jaafar's action was done in the course of employment, thus GMP was vicariously liability for Jaafar's wrongful act. To relate with the scenario, Gombak Wala Zoo is also vicariously liable to the negligence of Raju because it fulfills all three elements of vicarious liability. Number 1, the negligence is committed by Raju, who is an employee of Gombak Wala Zoo. Number 2, Raju is acting within the scope of his employment. Number 3, Gombak Wala Zoo has the ability to control Raju through employer-employee relationship. Gombak Wala Zoo is responsible to give the policy of working to Raju. So, they have the ability to control Raju. To summarize, Gombak Wala Zoo is vicariously liable for the negligence of Raju as Raju is their employee.
So, moving on to the second main issue, whether Selangor state government is liable for the negligence towards Ahpau for the injury he suffered. So, the first sub-issue is whether Selangor state government owes a duty of care towards Mr. Ahpau as their visitor. Firstly, the basic rule for duty of care is the neighbor principle, which involves an objective test. Would a reasonable man who is in the same circumstances as the defendant foresee that his conduct will adversely affect the plaintiff? If yes, then they are neighbors, so there is a duty. If no, then they are not neighbors, so there is no duty. The case that can be applied in this scenario is Lembaga Kemajuan Tanah Persekutuan and Mariam. The appellants engaged a contractor to weed and maintain a land scheme in Pahang. However, the contractor subcontracted the work without their knowledge, and the workers of the subcontractor live in a kongsi house built on the land scheme. The house collapsed, causing death of an employee of the subcontractor. The deceased defendant sued the contractor, subcontractor and Felda. Felda denied liability, contending that they owed no duty of care since there was no contractual liability. It was established that a person owes a duty of care even to persons who have no contractual relationship with him, and his liability to an injured person depends on whether the injury was caused by his act or omission. In the present scenario, the Selangor state government as the owner of the Gombak Wildlife Zoo must be examined for potential liability. The neighbor principle emphasizes the duty of care towards individuals who may foreseeably be affected by the actions taken, and this includes visitors to the zoo. In Lembaga Kemajuan Tanah Persekutuan and Mariam, the court ruled that duty of care exists when the harm is foreseeable and there is a relationship of proximity between the parties. Applying this to Ahpau's case, the Selangor state government as the owner of the zoo has a duty of care towards visitors like Ahpau. The unique Feed the Panda experience, being an initiative by the zoo, demonstrates an assumption of responsibility by the zoo for the safety of visitors during this encounter. The notices posted around the enclosure further indicate an acknowledgement of the potential dangers and the need for visitors to follow instructions. Therefore, the Selangor state government as the entity responsible for the zoo owes a duty of care towards visitors like Ahpau. In conclusion, considering the neighbor principle established in Lembaga Kemajuan Tanah Persekutuan and Mariam, it can be concluded that the Selangor state government is liable for negligence towards Ahpau for the injury he suffered. The duty of care is established through the foreseeability of harm and the relationship of proximity between the zoo management, representing the state government, and the visitors. The failure to ensure the proper restraint of the panda gives rise to the state government's liability for the injuries suffered by Ahpau. Moving on to the second sub-issue, whether Gombak Wildlife Zoo breaches their duty of care towards Mr. Ahpau. So what constitutes a breach of duty? A duty of care is breached when standard of conduct is not successfully reached and the defendant has fallen below the standard of care expected in someone undertaking the activity concerned. We can identify the standard of duty by using the objective test of a reasonable person. The defender's conduct is tested against the standard of care which would be expected from a reasonable person. And lastly, the question asked is what would the reasonable man have done or not have done in the circumstances of the case. The case that can be applied is Steven, Fuwa Cheng Lun and others, and Highland Properties SDN and others. So in this case, there is a Highland Tower which consisted of 3 blocks 12-story high, apartments named simply as Block 1, 2 and 3. After 10 days of continuous rainfall, Block 1 collapsed. The second defendant, an architectural draftsman, was the purported architecture of Highland Towers, and the third defendant was the engineer for Highland Towers. It was held that the second defendant, who was representing himself as a qualified architect, and the third defendant, who is a qualified civil engineer, was found negligent for faulty design and having issued a notice of the drainage, whereas in fact only 10% of the drainage implementation was completed. In Stival Fuwa Cheng Lun and others and Highland Properties SDN, BHD and others, the court emphasized that a breach of duty occurs when the standard of care falls below what a reasonable person would do in similar circumstances. Applying this to the current scenario, the Selangor State Government as the owner of the zoo has a duty to maintain a safe environment for visitors engaging in the unique Feed the Panda experience. However, the failure to properly secure the panda chain as observed by Raju, the newly recruited worker, could be considered a breach of duty of care. The reasonable standard of care would require the proper securing of the panda to prevent any unforeseen incidents, especially when visitors, including young children, are allowed to interact closely with the animals. Considering the objective test of a reasonable person, it would be expected that the zoo and the Selangor State Government to take all necessary precautions to prevent harm. The failure to do so, as evidenced by the improperly secured chain, constitutes a breach of the duty of care owed to visitors. In conclusion, considering the objective test and the standard of care expected, the Selangor State Government as the owner of Gombak Wildlife Zoo is held liable for negligence. The failure to properly secure the panda despite the awareness of the issue constitutes a breach of duty, as the conduct falls below the standard expected from a reasonable person in charge of ensuring visitor safety in a wildlife facility. The third sub-issue is whether the negligence of the zoo management causes damage to Mr. Ahpau. So for causation of damage, first plaintiff needs to establish causal link between the breach of duty of care and the damage itself. Second, causal link must be present, unbroken and not too remote. Causation in damage is divided into two, which are causation in fact and causation in law. For causation in fact, there is the but-for test, which must establish two things. First, whether or not the defendant's conduct has in fact caused the damage suffered by the plaintiff. And second, whether or not the damage would not have happened but for the defendant's breach of duty. So in the case of Hassan bin Natullah and Kerajaan Malaysia, the appellant claimed that the defendant doctor negligently damaged his spinal nerve during an operation, leaving him paralyzed. He asserted that the doctor's negligence in performing the procedure was the sole reason for his paralysis. The issue disputed is whether the doctor's actions during the operation procedure causes injury to the appellant's spinal cord. Evidence showed that the harm sustained resulted from delayed treatment rather than the doctor's negligence during the procedures. The claim was unsuccessful since there was no proven causal link between damages and the breach. The defendant's conduct does not cause the damage suffered by the plaintiff. Next is causation in law. So under causation in law, There is the reasonable foresight test in the wagon mount. So what happened in this case was the defendant's ship, the wagon mount, was refueling another ship and negligently spilled oil into the water. No effort was made to clear up the oil, and the wind and tide causes it to quickly spread to the claimant's wharf. Then welding operations was taking place on the wharf, which then caused the oil to ignite. The flames developed into a large fire which severely damaged the wharf, so if it is foreseeable that oil would seep into various parts of jetty and cause damage for its usage, then there is a causation. But if it is unforeseeable that fuel oil on the surface of the water would catch fire, then there is no causation. Moving on to application, for causation in fact, the feed the panda experience initiated and managed by the zoo under the government's ownership led to Ahbab's injuries. The failure to properly secure the panda by the zookeeper Raju facilitated the animal's aggressive behavior, relating the scenario with the case of Hassan bin Datullah and Kerajaan Malaysia, where the government's breach of duty resulted in injuries. It is plausible to argue that the Selangor state government, as the owner, had a duty to ensure the safety of visitors, and their failure in maintaining proper measures to establish causation effect. For causation in law, applying the reasonable foreseeability test from the wagon mount case, the Selangor state government is liable because the harm suffered by Ahbab was a reasonably foreseeable consequence of their actions. In this scenario, the government allowed a potentially risky experience, providing visitors access to feed a panda in close proximity. Despite the warning notices, the government should have reasonably foreseen the risk of harm if proper precautions were not taken. In conclusion, applying the reasonable foreseeability test from the wagon mount case, the Selangor state government is liable since the harm suffered by Ahbab was a reasonably foreseeable consequence of their actions. In the scenario, the government allowed a unique and potentially risky experience, providing visitors access to feed a panda in close proximity. Despite the warning notices, the government should have reasonably foreseen the risk of harm if proper precautions were not taken. The chain not being properly tied, coupled with the close interaction with the panda, resulted in an unforeseen attack. The government's failure to prevent such foreseeable harm do establish liability. Moving on to the last sub-issue, whether liability of negligence could be imposed to Gombak Wildlife Zoo. Occupier's liability is a legal concept that deals with the duty of care owned by a person or entity of premises to individuals who enter or use the premises. Under occupier's liability, the occupier has a duty to take reasonable care to ensure that the premises are reasonably safe for visitors. The rules of occupier's liability are often categorized based on the occupier's relationship with the property. First is landlord. Landlords owe a duty of care to both tenants and visitors. This duty includes maintaining the property in a reasonably safe condition, addressing known hazards, and fulfilling any obligations outlined in the agreement. Second is contractors. Occupiers is held liable if they fail to take reasonable steps to ensure that the contractor's work is conducted safely. Third is actual possession. The occupier in actual possession has the primary duty of care, while others may have responsibilities. The occupier in actual possession remains ultimately responsible for the safety of visitors. In the case of Lembaga Kemajuan Tanah Persekutuan and Mariam, the palace engaged a contractor to weed and maintain a landscape in Pahang. However, the contractor subcontracted the work without their knowledge, and the workers of the subcontractor lived in a costly house built on the lands. The deceased defendants sued the contractor, subcontractor and Felda. Felda denied liability, contending that they owed no duty of care since there was no contractual liability. It was established that a person owes a duty of care even to persons who have no contractual relationship with him, and his liability to an injured person. Selangor State Government, as the owner of the Gombak Wildlife Zoo, is considered an occupier in the content of zoo premises. The government, acting as the landlord, has a duty to maintain the zoo in a reasonably safe condition for visitors. This duty extends to the unique and potentially risky activities such as the Feed the Panda experience. In Ahbab's case, the Selangor state government is held liable if it is because they failed to fulfill their duty as occupiers. This would include ensuring the safety measures in the panda enclosure, such as properly securing the panda with a chain to prevent any harm to visitors. The government as the contractors contracted the zoo management or any third party to handle the Feed the Panda experience, they would be held liable because reasonable steps were not taken to ensure the safety of visitors during such activities. While others may have responsibilities, the occupier in actual possession has the primary duty of care. In this case, the zoo management as the entity in actual possession and control of the premises may also be held liable for the safety of visitors. In conclusion, Selangor State Government as the owner, landlord and potentially a contracting party may be held liable for negligence if it is established that they failed to fulfill their duty to ensure the safety of visitors, including the proper management of potentially risky activities like
Moving on to the main issue 3, which is the last issue in this presentation. It is whether there is a contributory negligence on behalf of Ahpau and his family. Before we go deeply to this last issue, first of all, we need to note that what is contributory negligence? Based on the judgment in the case of Ah Long and Dr. S. Underwood 1983, contributory negligence can be defined as when the defendant must prove that the plaintiff has failed to take a reasonable care of himself, which will eventually contribute to the damage or injury. Contributory negligence was a complete defense which reduces the amount of compensation payable to the plaintiff in proportion to his own contribution. The plaintiff injuries mainly caused by the defendant negligence. Contributory negligence defined in the statutory authority in Section 12, Clause 1 of the Civil Law Act 1956. It is mentioned that where any person suffers damage as a result partly of his own fault and partly of the fault of any other person, a claim in respect of that damage shall not be defeated by reason of the fault of the person suffering the damage, but the damages recoverable in respect thereof shall be reduced to such extent as the court thinks just and equitable, having regard to the claimant's share in the responsibility for the damage. So moving on to the rules, there are 4 elements that need to be considered by the judge when giving the judgment in terms of contributory negligence by children. The first one is that age of the children. The younger the child is, the lesser the degree of care attributable to the child. The second one is that objective dates, whether the children with the same age children as the plaintiff will acted the same way. The third one is the standard of care of an older child. The standard of care of an older child is the degree of care that may reasonably be expected from a person in the plaintiff's situation. And the last one, facts of the case. Court will look at the fact of the case and circumstances of the case. From this slide, it doesn't necessary that the plaintiff should fulfill all of these 4 elements, but these 4 elements means that the things that need to be considered when giving the judgment, when giving the punishment, either the children is negligent, either the children contribute to the negligence, and the punishment given if the children found guilty. As mentioned by Lord Denning in giving a judgment in Goff and Torts 1966, a very young child cannot be guilty of contributory negligence. An older child may be, but it depends on the circumstances. A judge should only find a child guilty of contributory negligence if he or she is of such an age as reasonably to be expected to take precautions for his own or her own safety. He or she is not to be found guilty unless he or she is a blameworthy. So moving on to the rules of the case. In British Railway Board and Harrington 1972. So the fact of this case is that a 6-year-old child entered a piece of land which was open to the public and frequented by the children. There was an electrified railway track owned by the defendant which ran across the land. The boy was severely injured when he went through a gap in the fence and step on the electric railway track. So held is that the House of Lords found there is no contributory negligence and the defendants fully liable. The occupier must take a reasonable warnings to people who might be on his premises. Moving on to the next slide is that a local case which is Lembaga Elektrik Negara Malaysia and Ramakrishnan. So the fact of the case, the plaintiff was a 10-year-old child who had climbed an electric pole which was under the control of the local government in order to free a trapped bird. He was electrocuted and thrown to the ground and suffered extensive injuries when he climbed that pole. They, however, did not put up any anti-climbing devices such as warning sign, barbed wires, or spike despite potential danger and its proximity to the footpath. So the held is that the defendant was found fully liable as they had erected, maintained, and controlled a highly dangerous pole of hidden lethal potentialities which was within easy reach of children. The defendant had breached their duty when they failed to put up warning signs and adequate anti-climbing devices. So the rules and judgment in the local case of Lembaga Electric Negara Malaysia and Ramakrishnan is derived and extracted from the case of British Railway Board and Harrington, which is the landmark case of contributory negligence of a children. So, moving on to the next slide, which is the application. The things or the elements that we need to be considerate in giving the judgment, which is age of the children. Based on the case of Cove and Thorn, the younger child cannot be liable for contributory negligence due to the fact that the children still lacking the capacity to knowledge the consequences of the action. Ashin is a 6-year-old child who is the younger child, and the ordinary child with the same age of Ashin would have done the same due to the excitement when they saw the pandas. Referring to the decided case of British Railways Board and Harrington, the defendant was found liable because the defendant has failed to take a reasonable steps of common humanity and common sense to avoid danger, especially for children. To relate with scenario, Ashin is still lacking the knowledge about what will happen if he done what he had done, and the defendant responsible to put up a more detailed warning and sign about the things visitors should and shouldn't do when entering the enclosure. Next application of the elements that need to be considered is that facts of the case. Referring to the case of Lembaga Electric Negara Malaysia and Ramakrishnan, the defendant was found fully liable as they had erected, maintained, and controlled a highly dangerous pole of hidden lethal potentialities which was within easy reach of children with no precautions. To relate with the scenario, Raju on behalf of the zoo management was exposing Mr. Apau and his family to higher risk of injury upon abandoning the loosely tied cage on the panda. Panda, which are wildlife treasure, should be securely tied as they can act uncontrollably if being let loose. Hence, the court will consider the fact that Raju, who should have known about the danger, had ignored the risk by underestimating about the size of the panda. So, moving on to the conclusion. To conclude, there is no contributory negligence on behalf of Ahpau and his family. Gombak Wildlife Zoo is fully liable to take a very deep precautions on the danger of the wild animals in the enclosure. Thus, Ahpau and his family entitled for damages.
So moving on to the soft elements, the Al-Quran verse that can be related to our scenario is Surah Al-Mu'minun verse 8. A'udzubillahi minasyaitonirrajim wallazina hum bi'amanatihim wa ahdihim ra'un. The believers are also those who are true to their trust and covenant. As narrated by Abu Hurairah radhiyallahu anhu, the Prophet said signs of a hypocrite are three. First is whenever he speaks, he lies. Second, whenever he promises, he breaks his promise. And third, whenever he is entrusted with an amanah, he betrays his trust. So here it means that Islam teaches its followers to hold amanah when performing their job and to be fully responsible of their work duties wherever they are. In this scenario, Raju is not being amanah in his work as he is exposing the visitors to danger, and he also doesn't follow the right work ethic that is set by Gombak Wildlife Zoo. As a student, we also need to be amanah with our homework. We need to do our assignment without plagiarism, submit it on time, and try our best not to procrastinate. This is because it is our duty to learn as a student and to fulfill our amanah. So that is all from us. Thank you.
Okay, that's all. Thank you so much.